Please be seated. We'll use the swap.
Good afternoon. Ms. Lyons, you still have the floor.
Thank you, Your Honor. Guys, excuse me. Can we start? Okay, sorry. Thank you, Your Honor. I will now continue for about 45 minutes, and my colleagues can watch the time for me. I wanted now to talk a little bit about the issue of Mr. Ongwen being a disabled client and what that means, both in terms of accommodation to his disability and also to fair trial rights. There is an intersection of these rights. First, I want to mention that the Convention on the Rights of Persons with Disabilities states that persons who are disabled must be accommodated, reasonably accommodated. Under Article 2 of definitions, it states that discrimination includes all forms of discrimination, including denial of reasonable accommodation. The defense position, as we outlined in our brief, is not that there was no reasonable accommodation, for example, in the sitting schedule to Mr. Ongwen's disabilities, but that it took 8 months to get this accommodation, despite the recommendations of the detention center, despite the pleas of the defense, despite any evidence we may have submitted in terms of the defense experts. But as a whole, the question for us was, it was slow. And this had a direct effect on Mr. Ongwen, who was a person who was mentally disabled, and his ability to meaningfully exercise his rights, his fair trial rights of participation, assistance to counsel, and other fair trial rights. But what I want to focus on here is, and this shows where the reasonable accommodation and fair trial basically intersect, is the most recent decision by the trial chamber to deny what was called a Rule 135 examination. This was explained by the prosecution yesterday, that parties have the right to request examinations, medical, psychological, psychiatric examinations of persons, and the trial chamber will rule on this. Now, this issue is particularly important because it involves fair trial. The right for a defendant in any court to decide whether he or she wants to give evidence on his or her behalf is a fundamental right. I mean, in my view, there are no ands, ifs, or buts about it. It's black letter law, whatever it's called in law schools, but it's there. It's simple as that. And here the defense was asking that an independent expert, not prosecution experts, not our experts, but an independent expert be appointed to determine if Mr. Ongwen, who has been diagnosed with various mental illnesses, was able to even consider the decision, make the decision, understand the consequences of that decision, whether he wanted to testify or not. This is very different than I or my colleagues in the first row as attorneys explaining to a client, you have the right to testify, this could happen, this could not happen, explaining the consequences. But as a lawyer, given the information that I had available and the team had available and that you heard in terms of Mr. Ongwen's mental state, not only from the defense experts, but also from confirmed fundamentally by your expert, Professor DeJupe, in 2016, it raised flags about whether he was even able. And before I could even feel professionally able to ask him the question, I needed to have speaking individually as an attorney, I needed to have an expert to tell me, yes, he can make a decision. He can understand the question. He can understand the consequences. That's all we were asking for, and this was denied. Now, the result of this was that Mr. Ongwen was placed in a position where he has never been able to decide the question. He could not decide, could I give evidence or not give evidence in this case? So this intermediate step was both a reasonable accommodation, in our view, to a disability, and secondly, it ended up being a violation of fair trial. Now, I want to distinguish this, at this point, distinguish two things. The mental disability is operating in this accommodation sphere in terms of how the proceedings are going on and what Mr. Ongwen's input or not is to those proceedings. It's a separate question which you decide as to whether the evidence you've heard meets the requirements of 31A. I'm not talking about that. The prosecution mixed that up a little bit, and I think that was maybe what was referred to a day or two ago as concept creep. I'm not exactly sure what concept creep is, but they're two separate issues, and I want to clarify that. And this is the problem, that he has been denied this right, and it's a fundamental right. At the same time, this decision was litigated, and at one point on our request for leave, the trial chamber stated that the accused may be mentally disabled. The question of whether the accused may be mentally disabled was never considered in the impugned decision. Now, this implicates his rights under the Rome Statute, Article 67, as well as his rights under international conventions pursuant to 21.3.
Miss Lyons, I'm
Yeah.
asked to tell you that you
Slow
perhaps
down.
slow down a little
Thank you. Okay. And I'm not wearing my headphones, so I didn't hear it. Thanks, Your Honor. His rights as a defendant his rights as a defendant were violated because he wasn't placed in a position where he could make the decision whether he wanted to testify or not and present evidence on his own behalf. And that's part of the rights under Article 67(1)(e). Now, whether or not an additional examination, an additional medical examination is required, has to meet certain standards. And you yourselves in decision, decision 1412 talked about the sufficient indicia that were required to meet the test for 135. You talked about indications suggesting the existence of medical conditions which may impact on the accused's ability to meaningfully exercise his fair trial rights, which the chamber is unable to resolve without the assistance of one or more medical experts. And that's at it's also in paragraph 12 at decision 637. Now, this is a different standard than we heard 2 days ago from the prosecution, who said the only basis on which, I'm paraphrasing, the only basis on which to request an independent medical examination is new facts or new evidence. That is not the standard. Your Honors will look at this and will look at the issue carefully, I know. But we are saying that the standard, in fact, was met. And the standard was met not only by our experts, Dr. Kina and Professor Vuga, but by the court-appointed expert, Professor Dejoop, and also by various reports from the ICC DC. And I would like to point out, I will not read from Professor Dejoop's report. It's a confidential document. There was some reading of it during the prosecution presentation. But I will say that we've talked publicly about the conclusions, and the three conclusions of major depressive disorder, post-traumatic stress syndrome, and dissociative disorders are all there. And the first two, for post-traumatic stress disorder and for major depressive disorder, are characterized, according to the DSM categorizations, as severe. Now, in the discussion of accommodation and disability and the rights of fair trial in our brief, we used the term disability blind spot. And the prosecution position on this a few days ago was there's no merit. Let me explain what I mean. I'm raising this as somebody who is physically disabled and has to watch herself because I miss examples of access or physical disability to other people, and I'm not paying enough attention sometimes to mental disability. Why? Mental disability is invisible. It's as simple as that. It's hard to see. We've had testimony from our experts that diseases and their symptoms do not show themselves 24/7 every day. The experts from the prosecution, certainly Professor Vershtal-Pust, and I believe Dr. Metzi, talked about fluctuation of symptoms. They come and go. So that a person who has a mental disability is not wearing it on his or her, a sign on his or her body. It's not on the T-shirt. I have a mental disability. It's not there. It's hard to see. And so that's why we concluded that sometimes when the trial chamber appears to us to not be looking at the disabilities of the client and not accommodating them fast enough or not believing there's merit to them, they were saying they may not be seeing the whole picture. It's as simple as that. And as I said, I know what the disability blind spot looks like and feels like. And all of us have it for different things. But I'm saying that it was just a question of the awareness in terms of what has to be done in this situation, and that's why we raised that issue. Now I would like to move on to the issue of the burden of proof of the affirmative defenses. We concur with the trial chamber's position in decision 1494 that an accused must never be required to affirmatively disprove the elements of a charged crime or a mode of liability, as it is the prosecution's burden to establish the guilt of the accused, pursuant to Article 66, pursuant to reasonable doubt. Now, at the same time, the trial chamber decided that the interpretations of the applicable law on the defenses, the burden of proof for the affirmative defenses, would be made in the judgment. Now, we've litigated this. We've lost. So, but I want to say the reason that we have been pursuing this is it's impossible. I mean, it's impossible to effectively act in the dark. Where essentially we have been operating in the dark as to what the burden of proof, whatever it is that you decide you will apply to the affirmative defenses, which are a huge part of our case. Now, we understand that this is not a free-for-all, the evidence, right? We understand that both sides and also the participants present evidence to you. That's one step. And at the end of the step, you make a decision on the evidence. That is a given. But what filters that evidence in between, that middle step, is the burden of proof. And that is the reason why we have been so adamant about finding out before we presented the evidence, or later, if we had to, what is the burden of proof that you're going to apply? Because then we may choose other evidence. We may decide it's not worth wasting the court's time or anyone's time here to present X when Y is what's needed to support the burden of proof. But we have no way to decide that without knowing what that burden of proof is. So we don't have the legal guidance on this from the trial chamber, and essentially we're operating in what seems to us as a legal quagmire, which prejudices Mr. Ongwen's right to a fair trial. Now, in their briefs, both the prosecution and the common legal representatives for the victims have taken up this issue. In the prosecution brief, paragraphs 380 and 476 deal with the issue of burden of proof. The position they take is basically that nobody bears the burden of proof. They don't bear it, we don't bear it, no one bears it, all right? Now, I think that this confuses, in their reasoning in that paragraph, the applicability of Article 31 and the burden. We understand that the chamber has the power to apply the law. That's the bench's role. But that's different than making a decision and giving legal guidance on the burden of proof. So we are now still here today in our closing arguments, not knowing what is the burden of proof that you will apply for the defenses of mental health defense and duress for the affirmative defenses we presented. Now, admittedly, the Rome Statute is not so clear on all of this. It's a little bit ambiguous. But generally, where there's ambiguity, due process requires that the resolution be in favor of the accused. And the Rome Statute has adopted this principle in Article 22.2, which basically says where there is an ambiguity in terms of crimes, and we would apply it to modes of liability and also to affirmative defenses, that it should be resolved in favor of the accused. Now, the reason we're applying it also to affirmative defenses, although it's not listed there, is that like crimes and allegations of crimes, affirmative defenses, they go to guilt or innocence, or you can change the wording, exclusion of criminal liability, but it ends up being the same thing. As also, Article 67, 1I says there's no reversal of burden on the accused. This would be a violation of fair trial rights. There's no onus on the defense. Now, the prosecution says in its brief that the trial chamber decision has acknowledged that the provisions have not been fully fleshed out by the court. That's true, but this does not say that no party has a burden, and that's what we're talking about. So that the question of what is a burden is different than what is applicable. And lastly, the issue of the trial chamber to decide, that isn't even a question. That's what we want, but we want a decision. Now at paragraph, we wanted a decision during the trial. Now the prosecution on the same subject at paragraph 397, they appear to reverse themselves. First, they've been saying, nobody has a burden. You don't have a burden, we don't have a burden, okay? But in paragraph 397, the last sentence says, and they're talking about mental disorders during the time of the alleged crimes. Their last sentence reads, no such explanation has been advanced. Those those 5 or 6 words are placing a burden on the defense to explain. In an affirmative defense, yes, we have to present evidence to show why we think it exists. That's all we have to do. That triggers the subsequent steps, but that is not a burden of proof. Now, the CLRV, similarly, at paragraph 157 of their brief, they take the position that the burden rests with the defense, because what they say is that, and this was repeated in the real-time transcript yesterday at page 53, none of the grounds for excluding criminal liability have been proven by the defense. In some, it's repetitive, but we have no burden. We've presented evidence to show that the mental disease or defect existed during the time of the charged crimes. And now it is up to in our view, up to the prosecution to disprove that defense, each and every element of it beyond a reasonable doubt. Now, the prosecution's interpretation of this issue of burden seems to carry over to their interpretation of some of the elements of the affirmative defenses. At paragraph 380, the same one, they say, the prosecution adds only that the use of the word destroyed in Article 31A implies that absent such destruction, an accused person is presumed to possess the capacity to appreciate the unlawfulness or nature of his or her conduct, and the capacity to control his or her conduct to conform to requirements of the law. Now, there's no footnote there. And it's our position that this conclusion was just made up by the prosecution. We don't have a source. We don't have a footnote. We would argue that there is no presumption, as they say, that an accused person is presumed to assume the capacity here. We would argue, pursuant to Article 22(2), again, that the elements have to be interpreted in dubio reo, in the light most favorable to the defense, in favor of the defense. When in doubt, this is the strict construction that is required by the Rome Statute. Along the same lines, the CLRV also adds another criterion, in our view, to the requirements of 31A. I don't have the paragraph here at the moment, but yesterday the representative talked about the severity of mental illnesses basically as a criterion for the defenses. Now, the statute at 31A talks about capacities. Capacities are very different than severity. And I simply call this point to the attention of the judges, again, using the authority of Article 22(2). These are two different things. Now, the issue of the defenses, 31A and D. 31A and D are separate. Yesterday's withdrawn. Yesterday, or 2 days ago, the prosecution presented a scenario where if the judges, they were suggesting, if you don't find 31A, then you go to 31D. There is nothing in the statute that says under 31(1)A, B, C, or D that any of the situations, any of the defenses, rather, here are in the alternative, or that you move from one to the next, to the next, to the next. They are separate. They stand independently. And I think as a matter of law and an analysis, that has to be a starting point from evaluating the evidence that we've presented. Now, is there a relationship? Yes. I discussed this in the question of the plea, ability to understand. It's raised in the proportionality criterion, which raises the issue of intent and ability to form intent under duress. So yes, there is a relationship. But that does not mean that you start with 31A, as was suggested, and if you don't reach that, then you move to 31D. And to complicate, perhaps, the scenario of the prosecution, we would assert that each defense, the mental health defense, as well as the duress defense, in and of its own right, is a complete defense. So that's our position there. Now, one moment. Now I would like to move on a little bit to the mental health section in my last 15 minutes. Now, you've heard extensive testimony from our experts, their experts. There were experts on some issues from the victims. You've heard a lot of testimony. There have been extensive reports, as well as from your own court-appointed expert. And this has been reviewed in the brief quite extensively. I want to just focus on a few points here. First of all, I would like to reiterate that both our doctors, our experts, and Professor Dejoop De Jong, Jup is his first name, De Jong concur on the fundamental three diagnoses, which are major depressive disorder, PTSD, other specified dissociative disorders. And in respect to the dissociative disorders, our experts identified both identity disorders and later amnesia disorders. And in addition, they identified symptoms of obsessive-compulsive disorder. Both talked about depersonalization and derealization in their reports, and as well as cautioned against a high risk of suicide in Mr. Ongwen. Now, our experts concluded that Mr. Ongwen's mental illnesses stemmed from his abduction in 1987, continued through the years in the LRA, and still plague him today. The continued through the years of the LRA includes the charged period. They were asked to make conclusions about his mental health during the charged period, as well as before and after. They were not asked to say what was his mental health for this criminal allegation A, B, C, or D. That was not the mandate. And that nor, as I think Dr. Aquina expressed, this was not their expertise. Their expertise was to assess mental illness. Now, I'm sure that everyone who heard the testimony remembers Dr. Aquina's vivid description of the trauma to which Mr. Ongwen was subjected, probably in the first months in the LRA, where he was asked, or where he was forced to skin a person alive. The person was an abductee who had tried to escape. And this is detailed in Dr. Aquina's testimony in T248. Now, the defense experts further concluded that these mental diseases and illnesses made it impossible for Mr. Ongwen to formulate intent in a sense that he could not tell. He didn't have the judgment to tell the right from wrong, and he didn't have the capacity to understand what he was doing in relationship to the law, conformity of the law. Now, there were some specific examples in their reports. They talked about when he depersonalized and when he dissociated, he could not control himself. They concluded that while in the bush, which was during the charged period, he did not appreciate that what he was doing, his conduct, was wrong. And they chronicled his involvement in the crimes of the LRA under the influence of dissociative episodes. They talked about, in both reports, two distinct personalities. So essentially, Mr. Ongwen, one person, one physical body, was operating in their professional expertise two people. These two personalities were identified differently gradually based on information, but this was from the inception, the information that was presented. And I would quote what they said: especially with dissociation, it is difficult for an individual to choose right from wrong under a pressing, life-threatening, stressful experience. During an episode of dissociation, an individual automatically without deliberate conscious awareness, assumes another personality for whom mental capacity to know right and wrong does not exist. You have the information before you, and you will make a judgment on this. We acknowledge, as Judge Smith eloquently pointed out, that there's always a problem of going back in time with forensic psychiatry. This was a problem which our experts were well aware. One has been involved in forensic psychiatry since the 80s, so you can calculate the amount of time. But based on the expertise and their expertise and their interviews with the client, their interviews with other sources, their review of the materials they were able to access at the detention center, they put together two reports which you have read and which clearly, in our view, make out the case under 31(1)(a). Now, the last two issues on this point I'm going to deal with and close up is the issue of malingering. Malingering has reared, as I say, in my view, ugly head, but has reared itself again in paragraph 403 of the prosecution brief. And basically, we again have the charge. The defense experts, according to the prosecution here, failed to use psychometric testing to rule out malingering according to best practice. And the footnote of best practice is Professor Verstol-Pust. Now, I'm not going to go through the examination and cross-examination. Again, I don't have time. But the point is, our experts explained that they had ruled out malingering, the basis on which they did it. Yet, the prosecution keeps up with its mantra, no psychometric testing means bad methodology. And we have to conclude that part of this exposes, on their part, a cultural blind spot. Because, in fact, there have been articles, for example, in 2006 by Ardila, A-R-D-I-L-A, which talked about cultural values underlying psychometric testing. I'm not an expert in psychometric testing, all right? It's used in mental health, it's used in employment, it's used all over the place. But take a look at what has been produced in terms of the literature. Routledge has a book on this, Cross-Cultural Neuropsychology. All I'm saying is these are important considerations as to whether you use and when you use psychometric testing, and what is the context, what is the culture in which you use it. What does it mean that instructions are given certain ways in cultures, in Western countries, in African countries, in Asian countries? And I could go on and don't have the time. But this is the issue. The DSM recognizes the need to talk about culture-related diagnostic issues. We don't have any disagreement about that. But it's important that this be dealt with, I think, head-on, and that's why we're raising it now. I also have to say, again, at paragraph 406, the prosecution makes a sweeping point that the defense says that cultural differences undermine expert opinion. This was never said. There was testimony from our experts refuting this, but it's important to repeat. They talked about the fact that they may share a cultural affinity or the same culture as Mr. Ongwen, that helps them to understand or to talk to Mr. Ongwen, but in terms of making a diagnosis, this was not the determinant factor. They've looked at other criteria that are recognized within the profession. Now, we concur with the CLR brief on this point. At paragraphs 33 to 35, they say, importance is placed on culture. They say, that cultural dimension presented ought to be taken into account in the trial chamber assessment of testimonies which it has heard. So I think that, culture obviously plays a role, but it is wrong, and it's wrong for the prosecution to keep saying that the defense experts say that culture is the key factor, the only factor in terms of diagnosis. It's simply wrong, but I rely on the record from our witnesses. The bottom line is, look, whom do you believe? You've heard the witnesses. You have 3 experts from the OTP, 2 from us, and then you have Professor, the court-appointed expert. So this is really, that's really a question at the end of the day. And I ask you especially, you heard Dr. Aquina and Dr. Avuga in this courtroom the last 2 weeks in November and then during the rebuttal case. And the bottom line is, do they appear to be psychiatrists whom a patient, if he or she were malingering or exaggerating or trying to get some kind of benefit, do you think that that person, that patient, would succeed in getting over on Dr. Avuga and Dr. Aquina, in tricking them, in making them believe something that cannot be justified scientifically and based on their observations? And that's really the decision, I think, with all due respect, that has to be made in terms of the experts. Our position is no. The answer is no, but it's not for us to decide. This is up to the judges. And lastly, on this topic, as I come to the end, I have to respond to the real-time page 74 attack from the prosecution on the defense experts, because it isn't professional and it's disrespectful. The defense experts, according to the prosecution, quote, seem to have gone to pains not to make themselves aware of voluminous testimony of Mr. Ongwen's behavior given in the courtroom, continues and says a few words, then they willfully or negligently cut themselves off from a vital source of information. The attacks of willfulness and negligence, in my view, have no place in this debate. Principled disagreement about conclusions, methodology, observations, that's part of what this is about. But attacks on willfulness and attacks on negligence become personal, and they should not be considered. This point should not be part of these proceedings. I have 1 minute to finish. And I think at the end of the day, it's going to be necessary for those who are judging the case to put themselves in the shoes of Mr. Ongwen, in his mindset, in the environment of the bush. And for many of us, this is simply not possible even to fathom. But it is the task that those who are judging this case, I think, may have to undertake. Mr. Ongwen is not just a person sitting in the back, flanked by security officers, who's been here for a couple of years, whose mental health has been analyzed and dissected, talked about in front of him collectively by 5 experts at least. He's a victim. In his own words, he says he survived the LRA prison. Those are his words, which he agreed I could use. This controlled his life for 27 years. And he survived, and he will survive the process however it ends. And it's now actually in your hands. We've, of course, asked for acquittal on all counts based on our affirmative defenses. But if the trial chamber reaches any verdict of conviction, we are also asking, which lead counsel will elaborate on, we were asking the chamber to suspend punishment and return Mr. Ongwen to Acholi land in the care of the elders so that traditional mechanisms of Matu Aput can be implemented. It's the defense view that this would best serve the interests of justice for Mr. Ongwen and for the community of which he's a part. And for the ICC, it's also our view that this would demonstrate its spirit of complementarity and cooperation with the existing cultural processes. Thank you.
Ms. Lyons, please close your
Yeah,
mic.
I know. Sorry. I got it. Thank you.
Mr. President and Your Honors, I'm up again. But I want to thank my colleagues for their very competent presentation of part of this morning and part of this afternoon. Mr. President and Your Honors, we have had a long walk, and we are at the end of that walk. Before I lose track of what my colleague Lion Beth has just said, I just want to add this. She said you have heard from nearly 5 mental health witnesses. I want to add that, Mr. President and Your Honors, excuse me, you also heard from cultural leaders from Acholi and Lango. You also heard from Ajuakas, so to speak, spiritual, cultural, spiritual practitioners. And because of that angle of interrelationship between culture and, mental health practices, that should be taken into account when the experts are dealing with, mental health. I think it is relevant for you to seriously address your minds to what they say. I will immediately turn again to my client, Mr. Ongwen. That boy, I want to constantly call him a boy because from my earlier submission, he has had such a disjointed life that the wheels of his life stopped on the day he was abducted. He's just attempting to rejoin the trail of life again. But alas, when he finally found his way out of the bush by risky escape and handed himself over to the authorities, instead of now rejoining him with his society, Ongwen has found himself here. This boy has served 27 years in Kony's incarceration. He has been here, Your Honors, for 5 years already. And I don't know for how much longer after this trial and possibly an appeal he will remain here. By the end of this process, and God forbid, if he should serve some sentence, the best part of his life will have gone. He didn't choose it, like I opined before. The choice was between Kony and the government of Uganda, complemented by the contributions of the international community. We call upon you to look at him with pity. Mr. President, of course, I will add a bit of that when I make my submissions about our prayers, so to speak. Mr. President, I will address a subject which has not been canvassed in this room very much. The question of superior orders. Superior orders. But when you talk about superior orders, there is a relation, I want to submit, there's a relationship between superior orders, there is a linkage, superior orders, duress, mental disease, and defect, as well as mistake of fact and law. And this is well captured under Article 33 of the Rome Statute. And Your Honors, the argument is that when you are considering the question of superior orders, duress, and so on and so forth, like I've said, you must consider provisions which deal with the list I have given in a comprehensive manner. Your Honors will remember that the concept of superior order, the world has grappled with the concept of superior order for a long time, and especially after I hope I'm not, I have now fallen back to my problem again, speaking fast, but the way I looked at the presiding judge, critically looking at me, maybe I have understood, sir. At the Nuremberg trial, as everybody who has been following legal arguments will remember, they came up with the position that superior orders is no defense. And people have been arguing back and forth, until when this idea finally came at the establishment of this court. And a colonel from in the UK Army said, well, this is now, he commented that the poisoned chalice was transferred to this court. To the diplomatic conference that was dealing with the question of drafting Article 33. I now say, Mr. President and Your Honors, that poisoned chalice has now been passed on to this court. Because the biggest question about that concept was, is superior order a complete defense on itself or on its own? Or is it just a relevant factor to duress, to mental disease, and defect to question of law, law and fact. And Your Honors, under Article 33.1, superior order is a factual, the question was, is superior orders a factual element relevant to other defenses, particularly duress? This is what we want you to attend to. It is a fact, Your Honors, that because of his spiritual attributes, omnipotence and omnipresence, and more importantly, because Mr. Ongwen believed them, Joseph Coyne's superior orders constituted duress. We submit that, therefore, Mr. Ongwen did not have to see a cocked gun aimed at him to apprehend imminent danger. It is enough that he believed in Coyne through, the spirits, believed in Coyne's ability to be present with him at any one time through the spirits. Hence, the correlation between superior orders and duress. It is also a fact, Your Honors, that Mr. Ongwen suffered mental disease and defect, as has been enunciated here, because of the pressure upon his mind exerted by the superior orders of Joseph Coyne, woven around spiritualism. This was also the same for his mistake that it was, and this is a mistake of fact, he believed that, it was the 10 Commandments. And the orders that came from the 10 Commandments, that was the law. And I emphasize this because, the concept of superior orders, which has now been planted under Article 31.1, is only allowable on two conditions. Condition number one is that the person was under a legal obligation to obey the superior orders. And then number two, that he actually believed. Now, when you talk about legal obligation, in the LRA, Your Honors, you want to find out if you're asking, was Ongwen under legal obligation? You want to find out what legal obligation. Because legal obligation would seem to connote that he is bound to comply as a matter of obedience under a certain body of laws. I am under legal obligation because of my professional standing to my client, because there is a law that binds me to that. How about Ongwen? Your Honors, we want to hazard to say that the law that Dominic Ongwen knew was the 10 Commandments. The 10 Commandments and what in ordinary legal parlance would be called the legislation, subsidiary legislations of Coyne that emanated from the spirits, or the spirit said it will be done like this. The rules and regulations that were set according to the 10 Commandments. And don't be misled. When we talk about 10 Commandments, it appears it's a holy thing. And if you were to follow 10 Commandments, thou shalt not kill, thou shalt not covet another man's wife, and so on and so forth. That sounds so fine. But That was not the case in the LRA. The 10 Commandments that Coin put in place was to be understood according to his own interpretation. And this boy was captured at the age of about 9. He had not known about any other law, because at that point, he's not presumed to know law at the age of less than 9. And so, he was he was made to know that the only law available in the world are the 10 Commandments of Joseph Coin. So I indulge you, Your Honors, to take cognizance of these facts when you are dealing with the question of whether Ongwen was under legal obligation. I submit that he was, yes, under legal obligation according to Coin's law applicable in the bush to obey those orders. Because Coin had set his own set of do's and don'ts. And if you didn't do according to what Coin told you, you died. And many died because of that. Mr. President, I would like to say that the prosecution totally failed, let alone attempted, to prove that Mr. Ongwen was not under a legal obligation to obey the superior orders of Joseph Coin. Secondly, Mr. President, the prosecution failed totally, let alone did not even attempt to prove beyond reasonable doubt that not only did Ongwen know the order was unlawful, but that he also knew that the order was manifestly unlawful. Mr. President, and Your Honors, it behoves this court, first of all, to come out with a clear definition as a matter of international criminal law, international criminal law jurisprudence as to what, in these circumstances, is meant by manifestly unlawful. Manifestly unlawful. Is it the case that it should be manifestly lawful according to international law in the context of LRA, or what is it? And when you talk about unlawful, unlawful according to which law? These are some of the questions you will have to ask yourself. To me, I studied law, but I was never faced with this kind of situation. If some people went, I mean, for instance, the slaves who were taken to the US, I know that finally they belonged, they had to comply with the US laws. But I'm sure deep in the jungles where they were taken to, plantations and so on and so forth, those people had exclusive, treatment of the slaves. Did they have to stand around, up and say, but according to the law of the United States, I am not supposed to do this. You are not supposed to beat me. These are some of the comparisons we shall have to make. Mr. President, in the circumstances, I would say that Dominic Ongwen was all the time obeying a superior order. And you know, in the case of the Nuremberg trial, they rejected the question of superior order just because it was mainly based on the fact that if they were to allow that, then it would boil down to only one person being held responsible. That was Hitler. But you know, the factual situation in Germany then and the international community was completely drastically different. First of all, that was a regular army, and they knew the laws of war, but in a situation like the LRA, and especially a child soldier who was arrested, who was captured when he had not exposed himself to the goings-on in the legal world, how was he expected to know? If you were talking about Vincent Oti, you're talking about Banya, who had originally been in a regular army, at least you'd say, yes, but these people knew. How about a child like this, 9 years, never exposed to any other thing, and he was indoctrinated and brought up by the hand, so to speak. You will have to, your honors, find out that he did not, he was bound by, superior orders, and I submit. Mr. President, your honors, on the question of sexual and gender-based violence, I invite you to studiously look at each element of those crimes and determine as to whether any of those charges, the way they were framed, stand. For instance, when you talk about sexual slavery, according to the elements of crime, connotes exclusivity, connotes ownership. Exclusivity in the context of marriage, for instance, means that you determine the fate of that person. Nothing happens to you, whatever you do to, because it's your possession. She is your possession. But evidence was laid here, your honors, by which it was said, if it was reported that you are irresponsible, you are disturbing a woman, Coin had the power to remove the woman from you and allocate and reallocate, so to speak. It is up to you to decide whether that connotes exclusivity. Coin dehumanized the women folk so seriously that they were just like chattels. You would allocate and reallocate. So they are, like chattels, you didn't own them. Actually, they were the property of LRA. You kept them at the pleasure of Coin. To me, your honors, I would strongly suggest that you find that there was no sexual slavery. There was no sexual slavery. And intercepts. I now go to intercepts. Sorry, I wish you had allocated us more time, Mr. President, but that is now neither here nor there. But, Mr. President, when we talk about, first of all, prosecution at the opening said more than, their case remain, they will depend on more than, 50% of their case will depend on intercept evidence. We have seriously attacked the intercept evidence. And I think fatally injured them. Supposing, I'm just posing this question. Supposing, according to law, because not according to me, according to the law of evidence, this intercept evidence collapse. And yet, by definition, if you have to prove something beyond any element of reasonable doubt, it means that you should prove them beyond 50%. Are they suggesting that I would suggest that their case should collapse with the collapse of the intercept evidence. And this is my last word on the intercept evidence. Mr. President, you heard from the witnesses, some of who actually recorded the intercepts. They described to you where they were recording from, the type of machines they were using. They said it was and the confusion which was at the Gulu office. People were fighting for position. And we established, because we kept on interviewing them here, so that they may actually tell us that they were at war with one another. And because they were at war with one another, you cannot ignore the possibility that there was destruction of documents in order to undermine the other. This is both for the recorded tapes and also the logbooks. Volumes of some of these, in their 600 and so on and so forth, were transferred to Kampala. I want you to critically examine the principle of chain of custody. The colonel who came here and is in the CMI told you how he kept them, spread them all over. And when it became necessary for him to pick some to bring for this case, he sampled some of them. And the way, when we asked them, were they safely stored, he was not sure about it. Actually, he said it was not very safely, they were not safely, stored. And then their transmission from wherever. All these are important to consider. We put the question to an expert who was brought here. Is it possible to transpose a section of, a speech between two peoples in a different situation and then cut and put it on another disk so that it appears like it was on the same day? He said, yes, it is possible. Mr. President, I'm saying you should be careful about this. And then last but by no means least, that boy lost his mother, lost his father, lost some of his relatives to the very war that enslaved him. When you are passing your sentence, think about him in that context. He's like an orphan. His society needs him. His siblings need him. The community needs his leadership. And my Lord, I say that you should find him not guilty. And if you find him not guilty, or whatever the case, should you be inclined to find him guilty on some charges, our prayer is that you give him very substantially reduced sentence. He has already served more than 30 years of prison. You can't add a lot more than that and hope in the circumstances. And the good thing is, my colleagues on the other side do agree that for the limited purpose of mitigation, they would say yes. The traumatic experiences count. So you could take a cue from that and use it to give and then, my last word, we have written to you a proposal in our brief to say, in the event that you are inclined to convict Ongwen, please release him and send him to serve part of his sentence, or the whole of his sentence, at home under the supervision of actually traditional leaders. And this does not in any way contradict the Rome Statute. In fact, my sister, Leon, has put it very well. The statute, this court is a complementary court. Is a complementary court. One of the ways you could express to the international community that this is a complementary court is to have a linkage with the system back at home. You will have done so many Christmas ceremonies for the people of Acholi and the affected people of Uganda. The question of the directional finding, I will not go into it because is it my... Oh,
You still have 13 minutes.
Can you imagine?
I do not say that you have to use them. I simply state that you have 13 minutes.
Mr. President, you know that I would want actually 2 more hours. So I can't sacrifice 10 minutes.
As I have said, you have still 13 minutes. Not 2 hours, but 13 minutes.
Very well, thank you. So, Mr. President, the question of what punishment you come with to give to Ongwen is not exclusively provided for under the Rome Statute. The principle of complementarity empowers you to think outside the box. Yesterday, Mr. President, was it on Tuesday, the prosecution through Mr. Colin Black, my friend Colin Black, who the other day I said, he's not black after all, he's a friend, said that, you know, you made a decision on the directional finding to say that, you know, they were unreliable and therefore they cannot be used. And Your Honors, I make these submissions to correct those the factual errors presented by the prosecution on Tuesday in relation to to our intended reliance upon directional finding materials. Firstly, while the prosecution discussed filing 555 and decision 596, the prosecution failed to represent the defense correctly, as it did not discuss filing 659 and decision 711. Your Honors, in decision 659 at paragraph 17, the defense stated, the defense hereby indicates that it provisionally considers the direction finding material reliable. Then in decision 711 at paragraph 11, the chamber noted that the defense was not barred from using this evidence. Secondly, Your Honors, prosecution analyzed P403, noted that the directional operation was an essentially separate operation from the interception of radio communications. That is prosecution witness 403 at UGA OTP or 272 or 466 at page 046, paragraph 60. On the other hand, P3 and P59 were not generally part of the directional finding operation. For these operations, Your Honors, several vehicles would be sent across northern Uganda in order to triangulate the signal. So it's not as if they would want us to believe. Thirdly, Your Honors, the defense notified the prosecution via emails in mid-2017 that it continued its pursuit about the direction finding material. The defense wrote 2 emails requesting meetings with P27 and P337. And that letter, the email states, finally, the defense asks that the witness bring with him placements of the mobile field stations for the directional finding material from October, November 2002 through July 2004, if it is available. The defense sought to authenticate the material. Finally, Your Honors, the defense conducted an interview with P27. This is found at UGA D26 0011 0508, page 0522 to 0523. P27 stated that issue directional finding units in the early 90s were able to get great locations so long as the LRA was using a high enough frequency to get a perfect location. The witness stated that band 10 or higher was ideal. During the charge period, Your Honors, the LRA was using between 7,000 megahertz to 7,000 to 8,000 megahertz. And this can be found at UGA OTP 0272 0466, page 0452, paragraph 20. Your Honors, band 10 is 3,000 megahertz to 30,000 megahertz. And the LRA was using a much higher band than 3, much higher, about 10 usually, as stated. And the LRA used, Your Honors, the only reasonable conclusion is that these directional findings are accurate. And as we said, we intend, and you did not stop us from using it. So the position that was given by our learned friends was completely false. Your Honors, I want to deal with crime sites. Your Honors, I'm going to briefly discuss the alleged crime locations. But let me first talk about evidentiary burden of the prosecution under Article 66. Although my learned sister and brother Taco have already talked about it, you know, for every crime site, what happened at the crime site, it is a duty, it is a burden of the prosecution to assemble their evidence around each of those, and prove beyond any element of reasonable doubt that it was Dominic Ongwen, either directly or as a co-perpetrator, that caused the crime at those scenes, at those locations. We deny each and every allegation that was made by the prosecution on Tuesday. But related to this, before I launch to each of the crime sites, logbooks. As a matter of principle, Your Honors, the defense does not revert to the logbooks as claimed by the prosecution when we deem them convenient or helpful. Not at all. The defense uses the logbooks to show inconsistency between the prosecution's evidence. the inconsistency in the prosecution's evidence. I respectfully submit, Your Honors, that it is up to the chamber to decide what to believe and what not to believe. Will the court believe the in-court testimony or the logbooks laden with human infallibility? While we may agree that the in-court testimonies were not always inconsistent with the logbook recordings, nevertheless, the occurrences in differences between them and the logbooks are far too many to ignore. A quick note in the inconsistencies can be seen in prosecution witness 209's testimony. He stated that Book Abudema was at Pajule during the Pajule attack. Yet, a logbook used in his testimony places Book over 60 kilometers away in a place called Adilang. On the other hand, prosecution 209, who was one of the main consumers of the information, stated at real-time transcript 161 at page 39 that the UPDF information about LRA operations was not always reliable. It's not you or me making these allegations, but a person who was using that information. It couldn't be any further from the truth. I now look at the Pajule crime situation. Mr. President and Your Honors, in relation to Pajule, the defense first and foremost reminds the chamber about Mr. Ongwen's injury and arrest within less than a year before. This morning, I talked about Ongwen's unavailability almost for the entire 2003. And at this point, maybe let me make a slight correction in what I said this morning. Was it, yeah? I think I quoted the wrong date. Instead of July, I said Ongwen, I think, was arrested in July 20th, and then he was released on July 22nd. I think all this happened in September. And it is to be found on page 28. Yes. Yeah. Yes.
Mr. Ayena, I won't, as we have always done so, when we have timelines, and I know you want to elaborate all your points, I will give you the time, but please keep the time also in mind.
Okay, please.
Yeah. I won't stop you here, as you know from the whole trial that we did not do that,
Yes.
but please keep it in mind what we have said before. What we
Please.
have agreed upon. Yeah.
Did you assure me that then I had 30 minutes? Now I
No,
have about
this
15.
is the problem is that obviously that my spelling was not, it was 13 minutes, and it might have been reflected in the transcript as 30 minutes. So I would not want to be bound by my misspelling. Yet there might be this might have created some sort of trust in you. So please continue.
Yes. Thank you, Your Honor. So anyway, let me go straight to the Pajule attack. The logbook, I mean, you can see the confusion about the logbook. Now, in the Pajule attack, the defense first and foremost reminds the chamber about Mr. Ongwen's injury. The injury made it impossible, we are saying, for Ongwen to have participated. And you remember, and we repeat, Ongwen was actually not a free person at all from the time he was arrested until he left the bush. How could Coin trust him anymore when he was now in touch with actually almost the alternative president? Because that general we are talking about is so powerful. And Coin had all reasons to really protect him. You remember, so that is the gray area I want to touch on Pajule. And the fact that, you know, at that time, Dominic Ongwen was a mere major. You remember the array of generals and colonels, including Oti. How could a mere major, whose character had been so seriously ravaged by allegation of treachery, be allowed to sit in that planning meeting? Then Odek, Your Honors, the prosecution appears to have given up on its attempt to prove that the career criminal, that is prosecution 245, was involved in the attack. As shown in the defense brief, prosecution witness 245 places the RV at Bolo, where everyone who lives in that area knows is on the opposite side, on the Ashua River from Odek. So the placement of Ongwen and the other reasons that we gave in our brief puts Ongwen away from that place. And then there is this fallacy about the walking distance, the average walking distance. Your Honors, you went there and you saw the terrain of the place, the thickets in the wild bushes of actually land in that area. Considering that he had to cross the river, how could Ongwen, in the state he was at that time, walk all that distance to go to attack Odek? That is preponderant. I mean, that is totally an acceptable thing to say. There are so many witnesses who would validate this. For lack of time, I shall move on to Odek, to Lokode. Mr. President and Your Honors, this is perhaps the most well-laid case of the defense about Ongwen's not being there. But let me add something about Odek. You remember that Odek is the home place of Joseph Kony. And Joseph Kony had a personal vengeance against his own people. So he chose the most suitable person to go and teach them a lesson. And the person he chose, you heard from the witnesses, was one of those people aligned to the control altar to go and take personal charge on Odek. And this is the man who finally is recorded to have reported the Odek incident. Ongwen was not there. And then we come to Abok. Your Honors will remember. And luckily enough, you went on a site visit to some of these places. The directions that were pointed for Ongwen to have come from, it doesn't fit. And then no single person, not a single witness, said conclusively that Ongwen participated. And yet some of the witnesses said Ongwen personally participated. Now, if you should find that, first of all, he did not participate, then you may draw inferences that there was some motive to lie about the situation. Somebody talks about a Bomek having been sent, but nobody concretely says it was Dominic Ongwen. They are just inferences. But all that said and done, Your Honors, we are saying, even if it were to be found that Ongwen was a co-perpetrator, at least, or even participated directly, he did so at the behest of Joseph Kony. Ongwen was acting on superior orders under duress, and he had no choice in the matter. And therefore, we pray that you dismiss all the charges against Mr. Ongwen. And I conclude in these terms. Your Honors, be it stated that the world is looking upon those of us in the courtroom to set a new standard for International Criminal Court. The world is waiting to see a new direction for how to handle child soldiers. For however long they live in the bush, so long as he was, unless he acted so manifestly recklessly, he should still be entitled to the protection of the international community. In the case of Dominic Ongwen, he more than fits the bidding of sympathetic consideration about how he was left with the devil's choice all the time. First of all, being left with the knowledge that even back at home, your mother is dead, your father is dead, by the very forces who exposed you to the vagaries of life. That has caused you so much damage in your life. Ongwen is a father to many children, not by design, but by imposition of coin. Because one of the things that coin was working for was to make these young men and women instruments of procreation. First of all, to establish a new actually, and secondly, to replenish the stock of his soldiers. Give Ongwen a chance to go home after 32 years. Whatever verdict you come with, the sentence should be so mild. I mean, of course, I know that we have been reading from the same page, and we pray that you acquit him. But in case he's not acquitted, our prayers remain as we have already stated. Give him a mild sentence. We shall talk about this during the sentencing. But we have just forewarned you so that you are forearmed. I thank you, Mr. President, and your honors.
Thank you, Mr. Ayena. Thank you, Mr. Taku. Thank you, Ms. Lyons. The Chamber wishes to thank the parties and participants for their hard work and industry to comply with the deadlines set by the Chamber throughout the trial. This also concerns the timelines set by the Chamber, as we have seen lastly, and I would even extend it to today. 15 minutes is not so much. We also wish to remember our colleague who supported the common legal representatives with her work from Kampala, and again transmit our sympathies to her family. Lastly, and also very important, the Chamber wishes to thank everybody in the registry, the interpreters, the people in the audio-video booth, the transcribers, the court officers, and the countless people working behind the scenes. They did everything in their power to enable the flawless and smooth running of the trial and showed great diligence in supporting the Chamber. All in all, things went exceptionally well with all the work done by the registry. And the Chamber does not take that for granted. We are grateful for this. This concludes the hearing.
All rise.